in your mind. Question number one, who is eligible to file a patent application? Yeah, first question. Second question, where to file a patent? Yeah. Third one, how to file a patent application? So starting with answering the very first question, who can file a patent application? Section 6 of the Indian Patents Act 19 defines file a patent, who is entitled to apply for a patent. The first one is true and first inventor. Oh, what do you mean by true? A true first inventor is a invention for the very first time himself. So this is the person who makes the invention for the very first time. He can file or she can. Yeah, why? Because they are the true and first inventor. Second entity who is entitled to apply a patent is the assignee of the person claiming to be first inventor. So now who is the assignee? Assignee person gets the patent rights from the original patent, which can be the first inventor. So there is a proof of assignment at the time of filing or within months from the filing of. So the deadline of filing the document of such application. Okay. Now let's understand the third entity. Suppose there is a before his death was in and then he died. So his legal representative, therefore, a legal representative who immediately before his death is entitled to can file a patent. With this, we can conclude that the three entities are entitled to file a patent. Yeah, alone or joint. These entities are first in number two of true and first in the was entitled to file the act that the that nowhere it is saying that an Indian citizen file a patent. Okay. So any foreign national can also file are following category. Either they are the or they are the first in or they are the legal representative for deceased lately before death entitled to file such. All right. So this was about the first question. Can file. But before ending, there is one section 134 plus it talks as to countries not providing. So basically, in the official gazette, there is a one country that accord the recipient the citizen that if citizen of file a patent application here, he will be right. Will not be told that you are an Indian, therefore you can't file. They will have to the Indian for filing the patent application. Therefore, the filing for the Indian as that of their own citizen. After the grant, all these conditions are met, said that the country rewards the recipient, the citizen. So, in that case, there is a country does not give, they can't give any kind of rights to. For example, Somalia, Afghanistan is there. They don't join in. So, if this the country that does not accord that kind of us, then India will also not give the rights of that rights will. Okay, so it's saying that there should be a equal exchange of the rights in game. So equal treatment should be there the citizens filing. So both sections are important. persons entitled to apply for, right? And three and 130 that whoever the reciprocity. Okay. So now there is another section we have to discuss, understand as to filer, and that is section number 6, section number 7. So this section 7 talks about the application. Generally, the application will be given form called form. So the form 1, form for applying a patent in which you have to give details like type of application, number 2 of the applicant, nationality, address of the applicant, and the category. There are also columns, such type of details are there, asked if you have to fill that out. Now let's see subsection 7.1. So section 7.1, that one patent is for one invention. If the controller sees that there is more than one invention in an application, call for division, and the resulting as a divisional application. We'll have a discussion on application upcoming, but just for consider this, that the one patent application have only one invention. If there are more than one invention and they do not them, then they will be asked to divide them, asked to bifurcate, and the resulting application as a divisional. Now, section 7.2 says, suppose the person is filing by virtue of assignment, that is, an assignee, then either on the day of filing the application or at any time within a period of 6 months from the date of filing of the proof of right to make the application has to be filed. So this deadline of 6 described in 10 over here, right? This proof of right means the assignment or the assignment agreement. So it will have this first. That's very the applicant also applicant it, his twice as an applicant as an inventor. Proof of right document really tells applicant and who is the inventor. There will also be a declaration right document by word sorry a declaration by the truth that so and so applicant of the by virtue of his assignment. All right. So this is your section 7. 10. Have seen is the person titled file a and in what form. So persons we have covered, and one, the person filing through signing. Second person being signing of the person they have to file assignment in the patent office within 6 months of filing the as per 10 section 7 10, right? This is about section 10. Let's go ahead. So this we have seen now let's answer the question where to file a patent. So you can see on my screen these are the 4 patents file: Delhi, Mumbai, Chennai, and Kolkata. So file in, so if you are from somebody from Haryana or Chandigarh, Delhi patent. If you are somebody from Goa, then you'll have to file in. I want each cover this very well as their question patent. All right. Now coming to the that we have to discuss is Rule 4. This talks about the approach. We have covered the territorial jurisdiction, the territorial, but what needs to be there at the that territorial jurisdiction. So it is that patent office those territorial limits, wherein the applicant of the patent, suppose there are two applicants, then we will look at the first mention, who is the first, and based on his domicile or place of residence, place of business, side the territory. You can check with the patent office corresponding to that. But what if he does not have a residence or in that case he has to give that applicant does have an address service. So as per rule 5, there is no address of communication. Then the controller can use his own discretion to not respond, not send out this type of applicant. So compulsory one of the applicant has to have a domicile or a place, an address of normally one address like the patent office, whether it's Chennai or Delhi. Once it's decided, it unless the controller changes it for some reason, that may happen. He transfer it from office to branch office. That can happen. But see, the head office Chennai. Okay, the others are branch office. So he may change that, but it's not that the applicant has the appropriate. Okay. So further, the rule 4 it also gives direction office for division application under section point subsection 4. So we will cover this part in detail, but for a complete understanding, let me give you a gist of sections. So basically, one patent application filed for one invention. If there are more than one invention not linked and they are filed in a single patent, then under section 16, the controller will ask the applicant to file a new application, the second type of invention. So basically, he'll ask to bifurcate the original. There were mentions one single application. So when a new one is filed, it prescribes that this application will also filed at the patent office as the appropriate office of the first application. Okay. So this is how where you find how to there are two online patent office promotes the online, and that is why an addition is applicable when applications for patent other documents filed through the physical mode opposed to the online. If you go through the online mode, you will pay 10% extra. So it's better that you file it through online mode. All right. Now let's discuss the document where and file along with fee. The first thing is covering letter. Second thing is form 1. Then form 2, form 25, certified true copy of the priority document. So we will go through each of these forms, the relevant also by one. Starting with very first covering letter. Covering letter is a document which are being filed with the patent application. This helps the patent office verify that all the required documents have been created. It a clear record of some covering letter. All right. Next, we have the application grant of patent. So this we have already covered seven. All right. In detail, but understand that one is universal application. It is used for all types of patent application in India. So as per Rule 20, sub Rule 1, Section 718, can be understood that for ECT national application, that is when an international application enters India, national must be filed in Form 1. All right. Similarly, Section 54, under Section 54, the patent of edition application filed, all right, and a patent covered. But the same Form 1 format is, it's just that the application it's a patent of edition act. All right. Lastly, convention application, Section 135. They are also application Paris are also filed through Form 1. So this is why Form 1 is very important section. If like it's the single prescribed form that accommodates types of patent application by having different sections that get filled application. All right. This was about Form 3. Before that, this is the fee, statutory fee for filing application. So a natural person can file the application Form 16. And if it's a large entity coming under the category of other than natural person, then they file it. So a natural person is the individual or a group of individuals, startups, or the research organization, education. Apart from this, let's say there are larger companies like Process or maybe HCL Technology or maybe Google, Microsoft. These come under the, all right. So the demarcation. Let's now Form 3. Okay. So now let's look at Section 8 of the Patent Act, which is the information regarding the foreign act. So this is a very important compliance requirement for patent application. Section 8.1, that is the sample Form 3 linked in the PPT. So this is how a Form 3 mention the name of the applicant. Then you mention the date of the application and the applicant. Have you filed it alone or joint? Mention. After that, you mention the date of the application, but status of the application, whether it's granted or it's pending or it's then the date of publication application. Lastly, the date of grant, date of disclosure. Okay? It's assigned to somebody, you mention that, otherwise the date of signature. So this is Form 3. And we have to cover Form 3 help of Section 8 and Rule 12. Okay. So if an applicant has also other country for the same or substantially, then they must file a statement Form 3 giving the details of those foreign applicants and an undertaking that they will keep controller updated writing about any such filing abroad until the Indian country. So this ensures that the controller knows where else the protection is for this amendment. Right? Then we have subsection 2 of section 8, which says that at any time before the grant or the refusal of a paper can ask the applicant to provide the details of the application processed, not just the filing, but also results, objections, or the grants. So the applicant is required to furnish the information available to them within the prescribed time. Where is this time prescribed? It's prescribed in 12. So Rule 12 deals with the procedural aspect of Section 8. So it says that Form 3 are taking and it will be filed within 6 months from the date of have filed the patent application in January. You are supposed to file a, even if you do not have filed for an application, then also you file for NA not applicable in, but you have to submit this even if you haven't filed a foreign patent application. But if you have, then definitely the details of those foreign applications also. So the applicant must update the controller about foreign application within. So there are deadlines. First one is just when you have filed the patent application. Within filing, within 6 months, you have to submit. The next Form 3 will be submitted within 3 months from the date of examination. So this is the second deadline that has to be adhered. Now, what happens? Applicant has to submit the Form 3 FER in it. The controller may also available like Google, USPT, Facenet, check the foreign application. Right? And lastly, the controller may furnish a statement once if required. This is a if he asks you submit a form 3, then the deadline is of okay. So within those 2 you are required to submit the form 3. Lastly, there is available. So if the applicant misses any of the 6 month deadline, month deadline by the FDR, or the 2 deadline from the date of communication, then in that case, the applicant can file a request form 4 to condone filing. Okay. So the fees of 4 is per month, 10,000 rupees or other than form for the fee for form. So it's better that you are there with these, otherwise you'll pay the extra amount. Right? So Section 8 compliance optional. Many patents have been or revoked based the failure of the foreign. So Form 3 might look simple. It's one of the most critical forms because not filing a Form 3 the ground of okay. So this is what is about Form 3. Next form that you are required to for a patent agent 20. So when a patent application is filed for patent, applicant must provide attorney 26. This authorization powers the patent act on behalf of the patent before the patent office. So there are certain sections that discuss. Section 127, which is the rights of, which says that every registered patent agent specific right under the act. They are in practice the controller. Number two, they are in time where transact the charge proceeding under the patent. So this provision recognizes the patent as a professional price to present the applicants before the patent. Correct? Next section that you have to understand, section 132. So at the same time, section 132 makes it clear that an applicant always act on their own. All right, they are not forced to appoint. They can, on their own, also represent patent office. Secondly, an advocate, not a patent before party. This is also point. Okay, so the act allows the flexibility of the self-representation or a representation by an advocate in the. All right. Lastly, we have 5, which is around the rule filing authorization. So Form 26 requirement must be filed in power of attorney under. This must be filed within 3 months from the date of filing the application. Until then, the controller will not process the application. Submit the power of attorney. Okay. Once the Form 26 is on board, applicant will send to patent and the service of the service on the as the service of the applicant. So if the patent office has emailed the first examination email, then patent office will consider that this has reached applicant on the very same. All right. So this is what it talks about. So Form 26 is not just a legal formality, the legal basis that allows act on behalf of the applicant before the Indian Patent Office. Right? So yeah, one more. Without a valid, the agent cannot transact the business for the applicant and the applicant unproper. All right. This is about the power of attorney 20. Let's move to the next form. Next is Form 5. So which is the declaration as to inventor. So we have read about proof right. Right, the inventors declare that this is the person applicant. We are assigning our rights to person. All right, who has the right to the patent application or put the property. So that is the proof of right. Now there is Form 5 which talks about the declaration of. In this form, basically the applicant declares that this are the inventors of the. You understand? So this is directly connected to section 10, section 10, subsection 6 of the Patent Act. 13, sub-rule 6, okay, of the Patent Act. So starting section 10(6) says that the law requires when first are must be furnished. So this declaration has to be made in the prescribed. It can either be filed alone or within the prescribed time after filing the. This prescribed time is mentioned in says that it must be filed. 13(6) is this one. You can read that exactly when Form 5 must be for an ordinary application. There are complete specifications filed at the outset. Form 5 should be submitted along with it. The case be filed within 1 month from the date of filing. Either you filed it along with the specification, just like you do, right? For proof of right, at 6 months' time. But for this declaration of mentorship, you just 1 month of file it. Further, you can also make a request of extending this deadline, right? Of extending this deadline of filing the declaration inventory. Okay. So there is also an explanation under 36 for internet PCP under PCP. So the date of filing of the complete specification counted from the actual date when the application is. So Form 5 is essential because it establishes who the inventors are. So this declaration basically prevents the it ensures that the credit is correctly. It helps in maintaining the integrity of the paper. So without a proper Form 5, the application can face the compliance. Okay. So this is what is about Form 5. The second last requirement is the certified priority document. Priority. So let's now move to an important requirement. So why do we need the certified copy of the priority? Because a application, when an applicant basically files an app, claims the priority from, and he claims the priority from an the Indian Patent Office. The earlier application actually exists, and the invention described here same as the one which was filed in the priority document. Okay, so that's where the priority document comes into play, and it's an earlier application certified by the first filing. The Rule 20 important which tells us about international applications under P. Such applications must be filed in. There is a clear time limit at national. By the time applicants are also a priority document. Similarly, Rule 21 has not already submitted the prior requirement is submitted application, right? But if you haven't, then it must be filed with the patent document. 1 month. So within 31 months from the priority, submit the priority document. So if this document is not in English, a verified English translation must also be filed along. If the applicant not submitted through translation, giving an extra 3 months to applicant does not provide the document or translate the additional. Then the priority regarded by the country. For all purposes under the Patent Act, the Indian application benefit of the earlier priority. So the certified priority not just a formality, absolutely critical for preserving the priority. If it is missed, the applicant will be the application will as if filed fresh, filing the earlier priority, and the applicant will lose out if has filed it. Somebody else files the application, all the priority lost, right? About the certified true of the priority document. Now let's move to the last aspect of the is 2. So Form 2, one of the most important documents in the patent filing process because it contains the specific So this specification may either be a provision or a complete specification. So let me explain constitutes a proper provisional application. Provisional application, it establishes your priority date when your invention is still at a conceptual stage. The key requirement for a provisional describe the feature of and features of the invention. Okay. Second thing, claims and abstract are not a part of a specification. Very important. But the fees is same as that of the most critical. The complete specification must be filed within 12 months from the date of filing the application. And if the complete specification is not filed, the application will be abandoned, cover the section. So this 12-month deadline is absolute in nature. Now coming to the next part, which is complete specification. So let's understand the complete specification and complete paired with the provision. So the complete specification has much more different requirements. So basic requirement is shall begin with a title and its own. So the title should be somewhat be fully describing. Second, disclose the best method of making the complete, the best mode working, the best mode requirement is third. End with a claim or so the most important component specification, the legal boundary, legal operative part, which defines the alright. So the complete specification cannot be without the claim. Okay, so claims should be always be at the end of the complete specification. Fourth part, it should be accompanied by an abstract, the technical information, the invention. Abstract is also compulsory. Now moving to the next, special requirements for the biological. You can see that this is a specialized area basically, but very important. So if an applicant mentions biological in the, for example, they about a microorganism or a plant species, animals, they have used it a product or if this material is not available to the public, then the applicant shall be complete by depositing that material. So the deposit of the material shall be made not later than filing or filing the patent application or on the date of filing the have to submit that biological. In India, you can submit at the microbiology, Chandigarh. And additionally, all the available characteristics of required for it identified the specification, including the address and the date and number of the deposit of the material. Okay. Then access to the material is available in the depository after the date of if a priority is the date of priority. Correct? So the specification must also disclose the source and source the geographic the biological when used an invention. Okay. Now there is also a requirement claims. So the claims specific to a or if they are related to the common inventive concept. The claims shall subsidiary clearly matter that is in the spec. Cannot claim anything beyond what you have discussed the specific. All right. And then a declaration of invention shall be described. We know that part 5. We covered this, right? Now let's see the fees for it. So filing has no, but if you go beyond, if your specific page, if you go to till 30 pages, the specific, but if you go beyond 30, let's say you filed with 31 pages, then you will have to if you are a natural. If you are an other than natural, similarly, if there are two additional, for example, 32 pages, then going to pay 800 plus 800, which is 100 rupees, right? Additional. Then similarly for the claims, up to 10 claims, there is no. But if you beyond 10, 20 for an actual other than per claim. All right. So statutory fee for the patent specific. This was the first aspect of today's contents of specific. I'll just take a 1 minute break to drink some water. Right, guys. Let's move ahead with the next aspect which we are going to cover today about the contents of. So starting with section 10, rule 13, rule 15, we are going to starting with the first one. Parts of a patent specification about this, but let me explain it again. So parts of a specific title, field of invention, background of invention, summary, brief description. The drawing sheets are there. Then detailed description of samples, claims, and the abstract. So these are the 9 parts of a patent specific, complete specific. Okay, so let's understand there. All right, so starting with the rule 13, a specification in respect of a divisional application under shall contain specific reference to the number of the original division application is made. It talks about that. So a patent applicant who desires file one or more application sections, including in respect of a invention proposed in the for the specific or a further application filed under section. Okay, so basically it's talking about every application, whether a provision or a made in form, first of all. Second, a specification regarding the divisional application and section 6 shall contain the specific reference in the description, the number of the original patent that you have filed. Parent applications number should also be made in the divisional application. Secondly, it's talking that a patent applicant desires file one or more further applications than one divisional application also. Okay. Or a further application filed and all of that having a reference number to the original application, which the divisional application. All right. Next, it's talking about same for the additional of addition application. So it's saying that these applications shall contain a specific reference to the number of the main patent, just like the above one, right? And it's saying that the application for as the find the statement that the invention comprises. The statement should be there of the modification and the invention claim specification, the division, the patent of addition or applied for is related to the main patent. Okay, where the invention requires an explanation through drawings. Such drawings shall be prepared in accordance with the rules, and it should be supplemented in the detailed description, or not in the detailed description, in the specification days. There should be a separate drawing sheets available for the reference purpose. So this is about rule. There are few sub rules for it. We are talking about number one is talking that there should be form two. There are provisional application can be filed in form. Second, it's talking about the divisional applications, providing a specific reference number to the original application. One. Thirdly, it's talking about the patent of saying this that you should specific reference to the number of the main. Then it's saying that you should be preparing the drawings according to if the drawings are there, the drawings are required for the explanation of the then that should be supplemented in accordance with provision of rule. We will see. All right. So this is talking about that. Then again, exec covered. Then in rules 10, sorry, 13.6, and then this is 13.7. 13.7a talks about, says that the specific shall begin and the title of the and describe the specific feature of the invention in 15 words. Covered this also words. You should be declaring this, right? Second, it's saying that the abstract shall contain a concise summary of the matter contained in specific, and the summary shall indicate clearly the technical field to which the invention belongs. Technical advancement of the should also be mentioned in abstract. Contain the chemical formulas also there and the characteristics in not more than one words. This is as per subclause C. Then it says that if specific contains any drawing, the applicant shall indicate on the abstract the figure. Exceptionally, the figures of the may accompany abstract when published. Abstract put a figure if the abstract is named through that. Okay. Now this is what it's talking about. And lastly, talking about the biological in 13.8. It's saying that the period within which months from the date of filing of, however, in case of a request for 24A, such reference shall be made or before the date of filing of. So we learned earlier that it has to be filed that, but Rule 13.8 prescribes the deadline of months from the date of filing. Forget to that, then this will create a problem. Okay. So, case of a request for publication, such reference shall be made filing of. Okay, so if you request for the early publication, then it should be before that. Okay, but if you are going through the, you can file it with 3 months from the date of filing of your submitted. Then we have Rule 14. It says that talking about the, we will cover this part later on in section. Keep it for now. Cover this with Form 13. Okay. Now we have about the requirements for the drawing sheet. It says that if the controller asks, it's saying that the drawings shall be furnished under section 10 by the applicant. Otherwise, on